Morning. Happy Wednesday. Welcome to oh my gosh.
I'll help you. WLG Group's Coffee Chat.
We're struggling through the week.
Yeah. The rainy weather is not helping either, but
yeah, more coffee needed.
More coffee, less allergies, more sleep, all the things.
All the above. Today we're talking about estate planning and divorce. So things to consider if you are working through a divorce or if you've recently been divorced. What do you need to do when it comes to your estate plan? So Lindsay, what's the first thing?
Well, I think the first thing is to understand that for estate purposes is a little different than when we're talking about like asset division from a divorce. So usually when you get divorced, there's a separation period and you might have a separation agreement that states, joint, assets are no longer combined, and there might be some kind of a date so that there's a way to calculate who gets what upon the final divorce. When it comes to estate planning though, or when it comes to your estate, if you are legally married, even if you're separated, as long as you don't have a prenup, I'll throw that in there, or a postnup, then if you have a spouse, even if you're legally separated, even if you've been not living together for 25 years, your spouse is entitled to what a spouse is entitled to. And that obviously depends on your situation. It's not cut and dry. Maybe your spouse doesn't get everything, but your spouse is still entitled to at least a third of your estate. So people ask us a lot. They're like, I'm in the middle of a divorce. I want to update my estate plan. And we have to give them that news that it's until it's final, there is a chance that if something happens, your spouse could still inherit part or all of your estate, depending on the circumstances. However, there's other things that as soon as you get separated, you can do. And that first one is regarding your incapacity documents. So why might we want to update those?
Yeah. So, typically people name their spouse as their primary first person, as an agent on their financial power of attorney and their healthcare directives. And, at that point, especially if they're effective immediately, which is our preference most of the time, that means that person can go in and make changes to your bank accounts, make changes to your, financial documents. So you probably, if you're going through a divorce, don't want that person to have that ability.
Probably not.
And then you probably don't want them to make your healthcare decisions at that point. It really depends on your situation, right? And what what is your divorce like? What's the relationship between the two of you? I know a number of our documents will state if the spouse is named as the primary and there's been a divorce or a separation, that the spouse is considered to predecease the individual. So at least in our non-statutory documents, we build in the ability that if you forget to update things, right, it won't be your spouse or former spouse making those decisions.
But because what if a very convincing spouse were to go into a bank with the documents and not bring along the separation agreement? So I wouldn't rely on that unless there's an actual divorce. But yeah, it is built in.
Some documents,
but not all.
Not the state statutory documents.
Right.
So if you have done a healthcare power of attorney or a statutory financial power of attorney, and you've named your spouse or former spouse as the primary person, you want to revoke that document and do a new one.
I think the other place you can do something immediately is your beneficiaries. So if you've got your spouse named on retirement accounts, life insurance policies, you can change those whenever you want. The caveat to that, though, is if you have minor children, don't just name the minor children as the primary beneficiary. These are cases where we like to talk about using trusts when there are minor children, especially, but also if you don't have a spouse. Because if you name a minor child as a beneficiary, they're not legally entitled to inherit. And so then they're subject to whatever the state laws are generally, or whatever you have in your will, which may or may not be updated. It depends. So you can go ahead and update your beneficiary designation to remove your spouse, but it might make sense. Well, it probably makes sense to chat with an estate attorney before doing so, just to see the best strategy for how to protect it. But at least it would go to your kids. It just might not be in the way that you want.
Right. So, and some of those, don't be surprised if you try to change some of the retirement accounts, especially. There are some employer plans that require the spouse to be the primary beneficiary without a waiver. So, if you go to make those beneficiary updates and they say, wait, no, you've got to prove to us that the divorce is final or have a waiver, just don't let that surprise you.
Right. And if you're working with a divorce attorney, then they can hopefully get your spouse to sign that waiver during the separation period. So there's strategies you can use, but like everything else we talk about, you need to plan, and you need to have a strategy and work with somebody to develop that strategy who knows what they're doing.
Yeah. So, all right. Well, that's all from us this week. And we are, we don't have any presentations or events for September as we get back into the swing of things for the school year.
Mm-hmm.
But we do have a presentation coming up October 23rd.
Mm-hmm.
So tailgates and trusts at Lone Oak Brewery, and we'll have that information up on the website soon. If you want to talk to us before that and get some more information on what to do, where to go with your estate plan, how we could help you, we'll drop a link to schedule a discovery call with us in the chat, and you can schedule a 15-minute call with either of us to talk about your situation.
Have a good rest of your
day.